growing.
Exhausted your time. Thank you.
Thank you, Judge.
All right, we'll call the next case this morning. Thank you, counsel. Ralph UDICK versus Harbor Hills.
Y'all didn't really have to switch.
Sir, hold off just a second and let counsel get seated and comfortable. Good morning, sir.
Good morning, sir. May it please this honorable court, my name is Ralph UDICK, Colonel, United States Army, retired. I'm the pro se appellant in this case, which is case number 5D14-2876, which is related to case number 5D14-2349, hereafter Bell Line. Oral arguments for Bell Line were just made moments ago. I'm deeply humbled and honored by this opportunity to appear before you. My case is about the unilateral and unauthorized amendment by the developer of the assessment scheme for my homeowners association. This amendment, known as Amendment Number 2, increased the assessments of the parcel owners and decreased those of the developer in violation of Florida Statute Section 720.306(1)(c) and at least 5 Florida case laws. As a result, the damage to me and every other parcel owner, as well as the unlawful self-enrichment of the developer, are huge. For the year 2010, when the amendment was effected, every parcel owner with a home paid $736 extra in assessments that year, while the developer paid $347,000 less in the same year. These numbers, of course, will change slightly in each succeeding year after 2010 as the budget and the property ownership mix change. At some $300,000 each year, the monetary impact of Amendment Number 2 is indeed huge.
Colonel UDICK, let me ask you a threshold question, and that is the impact of what we'll refer to as the Bell Line lawsuit. If that was a proper member derivative action, to what extent, if any, does that bind you? Because they litigated the effectiveness of Amendment Number 2 to Exhibit C.
Yes, sir.
And they struck out on that. They didn't appeal it. And maybe they should have. You know, that's a different issue. But the question I think that we have to ask ourselves at the threshold is, are you stuck with that result if that was a proper member derivative action?
Yes. That is one of the reasons why I'm appealing my decision.
Well, I understand
Yes.
why you're doing it. The
Yes.
question, though, is can you do it, or are you bound by the result that was obtained on that question? I think we all agree that that issue was litigated in the Bell Line lawsuit.
Yes, sir.
And that your position, I understand you weren't a party to the litigation.
Yes, sir.
Your position did not carry the day in that lawsuit. The question that I have is, recognizing that you weren't a party, are you bound by that? If it was my sense is this: if it was a proper derivative action, you're probably bound by it. If it wasn't a proper derivative action, you're probably not bound by it. So perhaps you could address the question of whether it is or is not, or was not a proper
Yes, sir.
derivative action.
I intend to do that. And I just want to make a comment in response to what you said. As far as a derivative action, there's no case law. Of course, you know, I'm just an old retired soldier, and the only law that I know is what I read, cases and so forth, in English. There's no case law, nor the statute, on derivative action that says that the results are binding. Of course, on the on the corporate shareholders, yes. But there's no case law that says another shareholder cannot, in his own right, sue on the same issue, because a derivative action is not a class action. And even a class action, you have to issue an order, then people have to be given an opportunity to appeal and so forth. I mean, to opt in or opt out. So this is really about my constitutional right to equal protection. So if I may.
Here's my concern, Colonel, with that argument, and that is if you've got 600 homeowners, you get 600 shots. So the first one tries and they're unsuccessful, it's not appealed. You bring this lawsuit, if you're not successful, are there 598 who can then bring lawsuits after you, and does a developer have to deal with 600 potential lawsuits? And if you hit on any one of the 600, you win.
Yes, I believe if that, theoretically, if that indeed happens, but in reality, that would be unlikely.
But isn't that really the whole purpose of a derivative action, is that whoever the plaintiff is, in this case, it was the
Bell Line.
Bell Line. Bell Line doesn't sue for their own personal benefit, they sue for the benefit of the entity, in this case, the HOA.
That's true.
And so, isn't that the whole purpose behind a derivative action, is that you have one plaintiff or a group of plaintiffs who essentially bring an action for the benefit of all of the either shareholders or members if it's a not-for-profit, and that everybody is bound by that outcome, even if the outcome might not be what they want.
True.
Now, I agree with you that there's a significant difference, bless you, there's a significant difference in a class action. You've got the ability to opt out. I think he's allergic to my question.
Well,
but you don't have the ability, if you have adequate representation, there's no ability to opt out in a derivative action. And that may not be fair, but that seems to be what the law.
I understand that completely. The only point that I'm going to make, and I will, briefly continue if I may, is that what I'm contesting is the application of res judicata of the Bell Line lawsuit that says Amendment 2 is valid. That is what so it's a matter of law about res judicata.
I think that really comes down to, if it's properly res judicata, I think, if it's res judicata, you're out of luck. If it's not res judicata, then you're in luck.
Absolutely, sir.
Okay.
Absolutely. I'll continue. The facts in this case scream equity. In the most important judicial holding in our nation's history in 1803, the United States Supreme Court in Marbury versus Madison held that it is a settled and invariable principle that every right, when violated or withheld, must have a remedy, and every injury its proper redress. 210 years later, in 2013, the Florida Supreme Court in Granada Lakes Villas Condo Association versus Metro-Dade Investment Company held that all courts have the inherent equity power and implicitly the duty to remedy wrongs notwithstanding any statutory or procedural limitations otherwise. The facts here document 3 wrongs that must be remedied. First, the court below, without any authority, applied res judicata to bar my cause of action based on a 2011 bench trial order in Bell Line that Amendment Number 2 is valid. I was never a party in Bell Line. I never received notice to participate in that trial, and I never had the opportunity to present arguments in that trial. Therefore,
Let me ask you about that. The sequence of events was Bell Line filed their lawsuit,
yes, sir.
and then you filed your lawsuit, and then there was the trial. Would that be a fair statement? In the
Yes,
Bell
sir.
Line case?
In fact, you're absolutely correct, sir. The Bell Line filed their lawsuit in February. I filed my lawsuit in November of 2010, and I will just concede now. I'll confess. The reason I filed my lawsuit because the complaint that Bell Line filed is public knowledge. I went to the court and got a hold of a copy of the complaint, and I read the complaint. And when I saw the glaring mistake, which is that they never contended that that Amendment Number 2 violated a statute, specifically 720.3061C, I therefore decided, wait a minute, they're not making the correct arguments in their complaint. So that's when I filed my lawsuit in November.
Let me ask you this. You just stated that you were not invited to participate.
That's correct.
In the lawsuit. Did you make a request to participate in the lawsuit, in the bench trial?
No, I didn't, but I didn't know that I had to. I didn't know I could even make a request because I was not a party in that
Due
suit.
process is often is notice and the opportunity to be heard.
That's true. I received no notice.
Okay, but you were aware of it. I don't think there's any.
Well, I became aware of it because, people talk and I actually went to the court and got a copy of the complaint, yes.
My concern on your due process argument as far as the opportunity to be heard is that you didn't make a request to be heard at that bench trial. And so, if you'd made that request to be heard and the judge said no, then your due process argument, at least, the way I look at it, would be stronger. But if you didn't make the request to be heard and to participate at that bench trial, then that gives me concern about the strength of your due process argument.
Well, I stand educated, but I did not aware that under the circumstances, since I was not a party, never received notice. And by the way, notice, if I'm correct, notice is the responsibility of the people that are in the trial that will tell other people to get in. By the way, when the bench trial was held in April of 2011, they already knew that I had filed my lawsuit, and they already knew that I alleged violation of statute as my primary cause of action, and they indeed did not invite me to participate in that bench trial. Okay, sir, I'll continue. I never had the opportunity to present arguments in that trial. Therefore, the court below has subordinated my interests to those of the appellees and violated my constitutional protection to due process and equal protection guaranteed by Article 1, Section 9, Florida Constitution, and the 5th and 14th Amendments, United States Constitution. This violation must be remedied. Second, the court below refused to consider my cause of action that Amendment Number 2 is invalid because it violates the law. It ignored my cause of action in my complaint and opted instead for a res judicata bar requested by the appellees. As a result, the validity of Amendment Number 2 as a matter of law was never even considered in my case. This is a denial of my access right to courts guaranteed by Article 1, Section 21, Florida Constitution. This violation must be remedied. Third and lastly, the unconstitutional res judicata order barring my complaint is a direct result of a lie that Bell Line is a class action. This lie was perpetrated by the appellee's lead counsel and accepted by the court below. This lie explicitly violated Rule 4-3.3A1, candor toward the tribunal, rules of professional conduct regulating the Florida bar. This rule mandates, and I quote, "A lawyer shall not knowingly make a false statement of fact or law to the tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer," unquote. Now, this lie is fully documented in the record. To this day, it has not been corrected as required by the rule. I believe such a blatant violation of rule is likely unprecedented, because it threatens the sanctity of the justice system and in the process violated my right to a fair trial. This violation then must also be remedied. So in conclusion, the remedy that I seek is a reversal and remand of this case to ensure my complaint that Amendment 2 violates the law can be adjudicated at last after 5 long years. I now end with a final request to this honorable court. If this honorable court should find my briefs unpersuasive and decide to affirm the court below, I humbly urge you to write an opinion. Then at last, I can look at a valid ruling based upon the law. But more important, as case law applicable to all citizens, it will benefit the 5+ millions of parcel owners in Florida. I will cite 2 written orders of affirmation rendered in 2004 that have greatly benefited the law. First, Promontory Enterprises Incorporated versus Southern Engineering and Contracting Incorporated by this honorable court, written by the Honorable Judge Sawaya, with the Honorable Judge Orfinger, who is presiding here today, concurring. Now, the second case is RAM of South Florida Incorporated versus WCI Communities, Inc., by the Second District Court of Appeal, written by the Honorable Judge Kennedy, now a Justice of the Florida Supreme Court. Both these case laws are very authoritative and instructive holdings regarding retroactive application of statutes and contracts, vested rights, and the enforceability of contracts that violate public policy. As such, they educate, they clarify, and they advance the rule of law that we all Americans so cherish. Now, my case may not merit a signed written opinion. A per curiam written opinion would also be most beneficial. However, a per curiam affirm without a written opinion, known as a PCA, would violate my due process without justification of law. Please, I urge you, do not do a PCA. I truly appreciate your patience and thank you for giving me this opportunity. This now concludes my oral argument, and if I have time, I'll reserve my remaining time for any rebuttal if necessary. Thank you.
Thank you. We've got about 3.5 minutes remaining.
Thank you, sir.
Good morning again, Your Honors. Phil Smith for the appellee in this case. As the court has already identified, this is simply whether or not res judicata was appropriate. Instructive is the case of Thompson versus Featherbridge, First DCA 472, Southern Second 773. It's a 1985 case. And basically, it sets out when res judicata applies. We start with the idea that it applies when there's an identity of the thing sued for. There's no dispute that we're all talking about the validity of Amendment 2, plain and simple. The second issue as to whether it applies is the identity of the cause of action. So again, it's a challenge to the validity of Amendment 2, and as stated in Thompson, the law requires only that the claims or causes of action be substantially the same. A request for different relief doesn't prevent the first action from serving as a bar to the second action. An identity of the cause of action is determined by the similarity of the facts essential to the maintenance of both actions. The facts are exactly the same because it's exactly the same thing being sued for. Additional arguments not considered by the trial court are not a reason to not have res judicata, because the bench trial, everything was brought that they wanted to bring, and when the bench trial was had, there was adequate counsel for Mr. Bell. He brought the causes of action that he wanted to bring, and there was evidence. The court heard testimony. So any additional potential theories would still be barred under the doctrine of res judicata, and that's Gomez-Ortega versus Dorton, 670 Southern 2nd, 1107. And it states, res judicata applies to all matters actually raised and determined, as well as all other matters which could properly have been raised and determined in the prior action, whether they were or not. So the next test is whether there's an identity of the person and parties to the act. And here, I think the court has already pointed out that in a derivative action, with Mr. UDICK being a member of the community, although he was not a direct party, he was a party in privity, as the cases state, and it doesn't have to be him as a named party in the
It was
action.
not a class action, correct?
It was not. It was a,
Trial court erred in its order when it said he did not ask that, he's a member of the class, and he had notice and did not ask to be removed or excluded from the class. Did he have an ability to move to be excluded if it was a derivative action as opposed to a class action?
well, in a derivative action, he would not have the right to be removed.
So the statement by the trial court that he did not ask to be removed or excluded from the class would have been in error, correct?
We believe the court's statement there was a harmless error. He wouldn't have the opportunity to remove himself. He certainly would have the opportunity to intervene. He chose not to for whatever reason. And so the judge's order on res judicata, even though it's not a class, that word is harmless error because we all can agree, I believe, that it was derivatively brought by counsel for Mr. Bell on behalf of everyone in the HOA. So the concept of the identity of the party, I think, is crystal clear. The last and final issue for res judicata is whether the identity of the quality or capacity against whom the claim is made. And what this element is talking about is, was it sufficiently litigated? This element takes care of the situation where if you had a similar claim that was maybe brought in county court and the other side simply chose to get a default judgment, the rights of the parties wouldn't have been fully adjudicated at that point. And courts are reluctant to give res judicata in that instance. But the facts here are that Mr. Bell and Ms. Lyon brought a lawsuit. They had Mr. Draper as their lawyer with Becker and Polyakoff. They had a trial before the court, 3.5 hours of evidence, testimony, legal argument. Clearly, the quality of that argument and case was sufficient for purposes of res judicata. Turning finally to the status of that matter, I think the court's already pointed out that there was no appeal of the bench trial situation regarding Amendment 2. Therefore, it's a final concluded order, and this court should affirm the court below, because as we all can gather from this, litigation has to end sometime, and res judicata is a mechanism to do just that. If there are any questions for the panel, I'll be happy to answer.
Okay, thank you, sir.
Thank you, Judge.
Yes, sir.
Thompson talked about 4 identities, and one of them is identity of the persons and parties. And again, I'm not a party. There's no law that I've ever read, case law, that says a derivative action is binding the same as far as res judicata. Now, yes, it's binding, but I've read no case law that says a derivative action can result in a res judicata bar. And so I'm just going to say I'm going to quote one case, Papa John Intern Incorporated versus Constantino, 916 SO 2nd 977 983. It's a Florida Supreme Court case of 2005. It is cited in my reply brief. It is established federal law that all 4 elements must exist where res judicata applies. 1, the prior decision was rendered by a court of competent jurisdiction, and that's true. There was a final judgment on the merits. Now that There's some dispute about that, because you see, the bench trial was not final. In other words, it didn't become final until well after my case was ruled on with the jury verdict. But here's the key, and I stress, the parties were identical in both suits. And we're talking about res judicata. And the rationale the court below used is res judicata. And it did say that I'm a member of the class, as Judge Palmer pointed out. The order is very clear. So it's very clear that with Florida law, federal law, parties must be identical in both suits for res judicata to apply. So I urge this honorable court to give me the chance. In other words, whether the amendment is valid or not, that's an issue that we've, that I have never had a chance to undergo, and there's been no scrutiny on my arguments versus what the appellees will make. So I urge this court to remand the case so that my cause of action can be adjudicated. Thank you.
Thank you both.